A complete guide to medical malpractice lawsuits in Ohio. This video is meant to educate the public about medical malpractice lawsuits in Ohio. At Piscitelli Law Firm, we represent clients across the state in medical malpractice claims. An Ohio medical malpractice lawsuit can arise when a patient is harmed because a medical professional failed to provide reasonable care. In this video, we'll explain how these cases work in Ohio, including the legal standards, time limits, and damages available to injured victims and their families. Piscitelli Law Firm is here to guide you through this process, answer difficult questions, and fight for the compensation you deserve. If you think you may have a case, contact our firm for a free consultation with an attorney, or visit getfrankgetjustice.com to use our chatbot for a free, instant online medical malpractice case evaluation. Understanding Ohio medical malpractice. Medical malpractice in Ohio occurs when a healthcare provider fails to meet accepted standards of care, causing preventable harm. This can include surgical mistakes, birth injuries, or other serious errors. These cases require careful investigation, strong evidence, and experienced legal guidance. Victims may recover damages for medical costs, lost income, long-term suffering, or, in tragic cases, wrongful death. Beyond compensation, malpractice lawsuits also hold medical institutions accountable for dangerous failures in patient care. What is considered medical malpractice in the state of Ohio? Under Ohio law, medical malpractice occurs when a healthcare provider fails to meet accepted standards of care and a patient is harmed as a result. These cases often focus on whether another professional would have acted differently in the same situation. Malpractice can include surgical errors, delayed diagnoses, medication mistakes, birth injuries, or even foreign objects left after surgery. Ohio law recognizes the serious impact of these errors and allows victims to seek compensation for medical costs, lost income, pain, and long-term suffering. Pursuing a claim not only helps families recover damages, it also holds negligent providers and institutions accountable. Most common types of medical malpractice in Ohio. Some of the most common examples of medical malpractice cases that may give rise to legal action in Ohio. Diagnostic errors, missed, delayed, or wrong diagnosis that allows a condition to worsen or leads to harmful treatment. Treatment errors, choosing an inappropriate therapy when safer, accepted options were available. Surgical mistakes, wrong site or wrong procedure, surgery, nerve or organ injury, foreign object left in the body after a procedure. Anesthesia negligence, improper dosing, failure to monitor oxygenation/ventilation, or ignoring known anesthesia risks. Medication errors, prescribing the wrong drug or dose, contraindicated combinations, or failures in medication reconciliation. Birth injuries, negligent prenatal care, failure to act on fetal distress, delayed C-section, improper use of forceps/vacuum, or unmanaged shoulder dystocia. Emergency department errors, triage failures, premature discharge, or ignoring red flag symptoms such as stroke, sepsis, or cardiac ischemia. Failure to monitor, not watching vitals, labs, or post-op status, missing deterioration that a prudent provider would have caught. Delayed follow-up on abnormal results, test findings never communicated to the patient or treating team, leading to preventable progression. Radiology and pathology errors, misread imaging or slides, failure to recommend appropriate next steps. Informed consent failures, not explaining material risks, benefits, and alternatives a reasonable patient would want to know. Hospital-acquired conditions tied to negligence, preventable infections, falls, pressure injuries, or wrong nutrition orders due to substandard protocols. Device and equipment issues, improper placement of lines/tubes, unsanitary or malfunctioning equipment, or negligent maintenance. What should I do if I suspect medical malpractice in Ohio? Steps to take include: 1. Request your medical records from all doctors, hospitals, and clinics involved in your care. 2. Document your symptoms, treatments, and expenses in a personal journal. 3. Save any correspondence with healthcare providers, insurers, or billing departments. 4. Seek a second medical opinion to confirm the nature and extent of the injury. 5. Contact an Ohio medical malpractice attorney to review your situation and determine if you can file a claim. How Ohio law defines and limits medical malpractice claims. While examples of medical mistakes help illustrate what malpractice looks like in practice, Ohio law sets specific rules that determine whether a case may proceed. Under state law, medical malpractice is not established simply because a patient suffered a poor outcome. Instead, the claimant must show that a medical professional failed to meet the accepted standard of reasonable care and that this breach directly caused the injury. Establishing this connection almost always requires expert medical testimony. Ohio courts also impose procedural safeguards that shape how medical malpractice cases move forward. Every complaint must be accompanied by an affidavit of merit, a sworn statement from a qualified expert who has reviewed the records and believes negligence likely occurred. Without this affidavit, the court may dismiss the case outright. How long do I have to file an Ohio medical malpractice lawsuit? One of the first questions in an Ohio medical malpractice case is timing. The law generally gives patients 1 year to file, starting from when the injury occurred or when it was discovered to be linked to a medical error. This deadline, known as the statute of limitations, is critical. Missing it usually means the case is dismissed, no matter the evidence. There are some exceptions, but the 1-year rule is the standard. The rules can be broken down as follows. Standard 1-year statute of limitations. An injured patient has 1 year to file a medical malpractice claim from the date of the injury or the date the injury was reasonably discovered. 180-day letter. If the plaintiff sends a written notice of intent to sue a medical provider before the 1-year period expires, the statute of limitations is extended by 180 days. 4-year statute of repose. Lawsuits filed more than 4 years after the alleged malpractice are generally barred, regardless of when the harm was discovered. Discovery rule exceptions. If the injury could not reasonably have been discovered within 3 years but is discovered before a 4-year period has passed, the plaintiff has 1 year from the date of discovery to file. Foreign object cases. If a foreign object is left inside a patient's body, the 1-year period begins when the object is discovered or should reasonably have been discovered. Minors and individuals of unsound mind. Ohio law tolls the statute of limitations in these situations, delaying the time limit until legal capacity is restored. These rules show how Ohio balances a patient's right to pursue justice with the state's interest in finality for medical providers. In practice, plaintiffs and their attorneys must carefully track both the 1-year period and the outer 4-year statute of repose to avoid dismissal. Missing even a single deadline can bar recovery, regardless of the severity of the injury or the strength of the evidence. Because Ohio courts strictly enforce these limits, anyone considering legal action should consult with an Ohio medical malpractice lawyer as soon as possible to preserve their right to seek compensation. Important to note, each case is unique, and the rules and triggers for statute of limitations may not fit the standard 1-year rule. Do not take this as legal advice, and always consult with a medical malpractice lawyer to determine your own statute of limitations. Gathering evidence for a medical malpractice claim. Building a strong malpractice case depends on proving how the error occurred and what harm it caused. The foundation of this process is collecting and analyzing medical records, which provide a timeline of treatment and reveal whether the standard of care was followed. Attorneys also work with experts who can interpret these records and explain how negligence led to injury. Without thorough evidence, even serious claims can be challenging to prove in Ohio courts. Evidence often includes complete medical records from all treating providers and facilities, test results, imaging scans, and pathology reports, prescription histories and pharmacy records, hospital policies, protocols, and surgical checklists, expert medical opinions linking negligence to injury, recoverable damages in medical malpractice and medical negligence cases. Compensation may include both economic damages, the measurable costs of treatment and income loss, and non-economic damages, which cover pain, suffering, and loss of quality of life. Victims who cannot return to work may also claim lost wages and diminished earning capacity. In cases of especially reckless or intentional conduct, courts may award punitive damages to punish wrongdoing and deter future misconduct. Each category of recovery is evaluated based on evidence, expert testimony, and statutory limits set by Ohio law. Types of damages include economic damages, hospital bills, rehabilitation costs, and long-term care expenses. Lost wages and future earning capacity, income lost due to time away from work or permanent disability. Non-economic damages, pain, suffering, emotional distress, loss of companionship, and diminished enjoyment of life. wrongful death damages, loss of support, services, and companionship when malpractice results in death. Punitive damages, awarded in limited cases to penalize especially egregious conduct by a provider or institution. Piscitelli Law Firm, representing victims of serious medical negligence. At Piscitelli Law Firm, we understand the toll that medical negligence takes on individuals and families. We are very selective in the cases we accept, focusing only on those involving serious injury, permanent injury, or wrongful death. We do this so we can dedicate all of our attention and resources to a limited number of clients, ensuring the best possible outcome for their case. Our team is committed to holding healthcare providers accountable and guiding clients through the legal process with clarity and compassion. Medical malpractice is one of our key practice areas, but our dedication extends across the full range of personal injury law to protect victims in Ohio courts. By choosing Piscitelli Law Firm, you gain a partner focused on securing fair outcomes and standing up for your rights in every case we handle.